The purpose of my speech is only to raise an overview to some selected issues on the topic implementation BEPS in the EU at the intersection between BEPS and the Belt and Road Initiative. But there are two areas to be highlighted, especially from the perspective of promoting foreign Chinese direct investment in the EU. First, the regulation of investment and taxation, and second, the need to strengthen cooperation in tax matters to assure an effective dispute resolving mechanism. In my presentation, I will address the topic around the two mentioned points, and I have selected only three aspects of the importance of the taxation and digital economy. The first one is the implementation of Action 1 of BEPS, addressing tax challenges of the digital economy. The second one is the implementation of the Anti-Tax Avoidance Directive. And third, the exchange of information momentum. As you know, base erosion and profit shifting affects all countries as a matter of trust. BEPS refers to tax avoidance strategies that exploit gaps and mismatches in tax rules to artificially shift profits to low or non-tax locations. In theory, when fully implemented, BEPS actions will render tax planning structure ineffective. Among the 15 actions defined by the OECD, I will focus today on three of them. First, the implementation and on the latest progress of Action 1, addressing tax challenges of the digital economy. Action 40, make dispute resolution mechanism more effective. And also Action 15, develop a multilateral instrument. Because the main challenge to me is coordination in Europe, and in this respect, multilateralism, especially dealing with treaty issues, is a key element on the process, although its final outcomes remain to be seen. As China's key trading partner, the EU is interested in coordinating a strategy to open up the doors to China's investment also in the tax field. This is the main challenge for the EU. And in this regard, the 19th EU-China summit held in 2017 advanced a bilateral strategic partnership highlighting joint commitments to addressing global challenges and the promotion of multilateralism. This is why the European Parliament has also remarked that the EU insists on a multilateral governance structure and on non-discriminatory implementation of the Belt and Road Initiative. Nevertheless, unilateral and bilateral measures are taking place in some states. Let's see to the recent outcomes, some success achieved. The BEPS project is still, as you know, a work in progress and will continue to be so in the coming years. The EU has driven the implementation of BEPS forwards in many respects. Some key BEPS measures have been translated into binding EU law, so they are implemented across the EU member states. Of the 15 actions BEPS, the EU has already taken an active role in respect of 10 of them. For example, regarding Action 1, the European Commission issued 2 proposals for new directive on digital economy. The anti-tax avoidance, the ATAD 1 and ATAD 2, addresses the recommendations contained in BEPS on Actions 2, 3, 4 and 6. In the context of Action 5, transparency, the EU has adopted the Directive on Exchange of Information of Tax Ruling, and a Commission recommendation on the implementation of measures against tax treaty abuse that has adopted in 2016 urges Member States to adopt general avoidance rules and to amend the PE definition in their tax treaties, in line with BEPS Actions 6 and 7. The directive on new mandatory transparency rules for intermediaries and taxpayers broadly reflects the objective of Action 12, disclosing aggressive tax planning agreements. And with the country-by-country directive, the EU introduced into legislation Action 13. And lastly, in line with the recommendation set out under Action 14, the EU has adopted the Tax Dispute Resolution Directive, setting forth the rules for a mechanism to resolve disputes between Member States. Most of the EU measures have already been adopted and constitute part of the EU legislation. In any case, distinguishing long-term tax reform from interim measures is crucial in this process. At the OECD level, different options have been analysed. However, the last report shows a lack of consensus and a tremendous difficulties to advance towards a generally accepted new model based on user contribution, marketing intangibles, significant economic presence, and so on. At the EU level, there are also interim and long-term solution proposals. However, the ECOFIN held in March has rejected the introduction of an interim tax for digital services on a global basis within the EU. Whether it is good or not, the fact is that interim unilateral measures are being adopted. They can be summarised in these 5 categories: PE digital presence in Austria, Indonesia, Thailand, net digital in Germany, Hungary, dietary profit tax in Australia, in the UK, the gross WHT, the equalisation levies in India, Italy, France, UK and the EU, failed in the EU, and lastly, service PE concept in Saudi Arabia. As the chair of the Business and Industry Advisory Committee to the OECD Committee on Taxation, Mr. Morris declared, if one country wins, then another country has to lose. For international consensus, then, the countries that lose have to agree on whatever solution comes out of the process. Looking for an appropriate balance between the ambition of a straight-driving model and the inclusiveness of transnational policy network model will be of central importance for the Belt and Road Initiative investment governance. And non-state actors play significant roles in this rulemaking. In the 4th regional meeting of the Inclusive Framework on BEPS for Eastern Europe and Central Asia, held in November 2018, the need to promote the new rules to taxpayers and to enhance legislative and organisational resource capabilities, as well as cross-country cooperation, was stressed. For example, through advising pricing arrangement, mutual agreement procedures and exchange of information. According to some official data, China has acquired assets in Europe for at least $318 billion. Likewise, the EU outward foreign direct investment in China has steadily decreased since 2012, particularly in the traditional manufacturing sector, with a parallel increase in investment in high-tech services, utility, as my colleague explained, agriculture and construction services, while in China investment, the EU has grown exponentially over the past few years. Since 2016, China has become a net investor in the EU, and in 2017, 68% of China's investment into Europe came from state-owned enterprises. Coming back to the digital economy, The permanent establishment concept and the problem of the nexus are the most important challenges in the way of finding a long-term solution to the digital economy. Under the OECD and G20 scope, different proposals have been held for the establishment of a fair taxation of the digital economy. On March 2018, the European Commission issued two proposals for new directive. As an interim solution, the one referred as to the digital service tax and long-term Council directive laying down rules relating to the corporate taxation of a significant digital presence. The digital service tax was failed in the last ECOFIN, and this proposal has postponed at least for the next years. Tax avoidance is a legal concept that emanates from the interpretation of either statutory general anti-avoidance rules, sometimes also from target and specific anti-avoidance rules, from the judicial creation of these general anti-avoidance rules, or a principle of abuse, or from the reconciliatory interpretation of all the mentioned sources. According to the EU Anti-Avoidance Directive, adopted in 2016, Member States must apply the anti-tax avoidance measures from January 1st, 2019 by enacting new measures or amending existing ones. According to its preamble, the ATAD should provide for a common framework in order to prevent a fragmentation of the market. The objective is to ensure a uniform implementation of the BEPS package within the EU. However, Article 3 stipulates that the directive provides for a minimum standard. This means that if the ATAD sets minimum standards, Member States can impose more restrictive ones and go beyond that standards. The Directive on Exchange of Information of Tax Rulings is a key legal issue also for the BEPS actions implementations. The amendment of the Directive on Administrative Cooperation covered tax ruling going back 5 years from the date of implementation from cross-border, still valid, tax ruling, and 3 years for those no longer valid. The Directive entered into force in December 2015, and Member States were due to adopt and publish by December 2018 the law, regulation and administrative provision necessary to comply with the Directive. The Commission will receive a limited set of information for monitoring and assessing the proper application of the exchange of information, but this cannot be used for any other purpose. The exchange will be run over a 6-month period. In a BEPS environment where tax administrations may react by implementing new rules reinforcing their tax bases, the number of disagreements between and among states about their entitlement to levy taxes may be expected to increase. For lawmaking, it must be noted that as of 2018, China has concluded 54 double taxation agreements with the Belt and Road Initiative participating states, including the international arbitration clauses. We have seen in the presentation of my colleague that 109 double agreement is the current data of the level of the agreement raised by China. As Mejía Lemos pointed out, as for dispute resolution, many disputes are likely to arise out of the Belt and Road Initiative projects and to be submitted to international arbitration. Expecting an increased demand for dispute resolution services, various arbitral institutions have updated or are in the process of updating their arbitration rules and adopted specific. China's government has also sought to address that demand by establishing China's domestic forum for the settlement of the BRI disputes in the form of international commercial courts, two of which were inaugurated in June 2018 by the China Supreme Court. With particular reference to tax disputes, international arbitration may prove useful in order to address some of the limitations of existing tax dispute resolution such as negotiation between tax authorities. Regarding tax dispute resolution, in October 2018, the EU adopted the Tax Dispute Resolution Directive, setting forth the rule for a mechanism to resolve disputes between member states when those disputes arise from the interpretation and application of agreements that provide for the elimination of double taxation. Member States have until 13 June of 2019 to transpose the directive into national laws and regulation, and it will apply to complaints submitted after that date on questions relating to a tax year starting on or after January 1st, 2018. Although multilateral treaties and bilateral treaties extra-EU are not concerned by the ACMEA doctrine held by the Court of Justice of the European Union, the Court of Justice is assuming a belligerent role defending its competence for the resolution of disputes between member states concerning the application of the EU law. And this is an important data to take into account also in tax treaties. The conclusions are very simple. The People's Republic of China and the EU are actively involved in actions to promote transparency, equity and a fair system of dispute resolution matters. The EU has implemented different measures on BEPS and are particularly relevant to this workshop, those related to digital economy and exchange of information, anti-tax avoidance and also dispute resolution mechanisms. China is, without any doubt, a leading actor on all these matters, and the viability of real change in the international tax model depends very much on its approach to these issues. We are in a period of change. We have seen the signal of changes in your presentation, and we need a clear direction of travel.